that balancing is inappropriate when the state is trying simply to shut someone down because the individual is expressing a minority or dissenting opinion. So there is no state objective that can ever justify state action designed to shut down someone on that basis. So if we win that, we will change the way that courts in the country are looking at free expression currently.
The case against persecuted former Ontario physician Dr. Mark Trozzi may signal what the future of justice and free expression will look like in Canada. Trozzi was among the first doctors to challenge the COVID narrative, joining David Menzies in May of 2020 to reveal that hospitals were empty, which was contrary to the claims of them being overwhelmed at the time. After lengthy proceedings with the College of Physicians and Surgeons of Ontario, his regulator, the CPSO, a disciplinary tribunal ruled last fall that Trozzi was guilty of, holding unacceptable views, branding him as engaging in professional misconduct and incompetence for spreading alleged misinformation and daring to write medical exemptions for patients pressured into receiving the novel, still in clinical trial, modified RNA COVID injections. Trozzi's lawyer, Michael Alexander, brings over 30 years of experience in various legal areas, including constitutional and administrative law. He joins me to discuss the appeal he will be presenting tomorrow to the Divisional Court on October the 8th, including the arguments, implications for free speech, and the hurdles encountered along the way. First, Alexander delves into the evidence, or lack thereof, that prosecuted Trozzi.
It was primarily based on expert evidence. So they brought in 3 experts, two on the science, actually, Dr. Michael Gardam from U of T, Dr. Noni McDonald from, I believe, Dalhousie. And then third was Dr. Orkin. He spoke to medical exemptions. So they relied primarily on the experts who, and really it's Gardam and McDonald on whom they placed their primary reliance. So they argued that Mark had caused patient harm, or his statements and his actions had the potential to cause patient harm, and that he was not making statements consistent with the scientific consensus about COVID-19 science. So their testimony is very problematic, and I guess it would be fair to say that I impeached them on cross-examination. So, for instance, Dr. McDonald presented a general report about the harms caused by the spread of misinformation about public health. But in cross-examination, she admitted that she didn't try to connect that to Dr. Trozzi, and she said that she didn't even know who Dr. Trozzi was and what he did. So that's the quality, just to give you a sample of some of the expert evidence. Dr. Gardam, for example, claimed that it was beyond true that the shots are, so to speak, safe and effective. He said they've been given to billions of people worldwide safely and effectively. He had no scientific references for that statement. In fact, he made the statement more than once. But no references, no citations. So that is just a subjective assertion.
Now, many of these so-called experts are plagued by conflicts of interest. Take Noni McDonald, for instance. She was on the World Health Organization's committee addressing vaccine hesitancy before the COVID hysteria began.
Vaccine hesitancy is one of those things that's crept right into the general conversation, and unfortunately, it has missed some of the definition pieces. So I sat on the committee that did the World Health Organization definition for that. And to be vaccine hesitant, it means that you are not accepting a vaccine even though it's available. So if you can't get a vaccine because it's not at the clinic where you are not hesitant because you're not getting it. And it varies by context, by time, by place, and by vaccine. And we know 3 major factors influence it: confidence, complacency, and constraints or convenience.
MacDonald also actively participated in the Public Health Agency of Canada's Behavioral Modification Campaign, an extension of the World Health Organization's Behavioral Insights Unit aimed at bolstering uptake of the COVID-19 vaccine through the My Why campaign.
I am a firm believer in the benefits of vaccines. So, of course, I planned on getting the COVID vaccine as soon as I was eligible. I'm a healthcare worker and I'm old. So I was able to be immunized here in Nova Scotia in those categories in March. And I'm so pleased to say that I've had both doses of my COVID vaccine. I think everybody should get immunized against COVID. This is a wicked virus that causes many bad infections. And as you all know, many people have died. It's really important that all of us get immunized because I'm only safe if I've been immunized, if my family's been immunized, if the people in my community have been immunized, the people in my province have been immunized, and the people all across the country and all the countries in the world are immunized. Why? Because all of our vaccines are not 100% effective, just like there's no drug that's 100% perfect. So for us to all be protected, we need everybody across the globe protected and immunized against COVID.
Now, one of the key arguments in Trozzi's case is not only his expression of a dissenting minority opinion or viewpoint, something that we thought or think is protected by the Charter of Rights and Freedoms, but that the college lacked the legal authority to investigate doctors critical of COVID-19 measures, as these measures were only recommendations or guidelines and not legislated laws or regulations.
Well, one issue which you've already mentioned is the use of guidelines. The Ontario Court of Appeal has said that policies and guidelines of administrative bodies are non-statutory instruments. What that means is that they do not have the force of law. But the college, from the very beginning of this prosecution, has tried to take various guidelines that they post on their site, including guidelines about COVID-19 issues. And they've tried to enforce those as if they are the law, and they're not. So this is an ongoing dispute that will be raised during the appeal hearing. It goes to what the true legal foundation is for their prosecution. Is it guidelines or is it something else? In fact, you can make the case that their investigation orders were based on guidelines, and you have to have a specific offense in an investigation order in order to conduct a search and seizure operation or arrest somebody or interview somebody. Right? So it's the same standard that would apply for a criminal warrant. The standard is reasonable and probable grounds. That's the standard the college is held to. But in their orders, there's no reference to a specific offense. So that's the starting point. What did the person do wrong? And they're very vague about that. Clearly, they're making some kind of oblique, it's a bit of a paradox to say this, but clearly they're making some kind of oblique reference to their guidelines. But they didn't want to say guidelines motivated them because then that would delegitimize everything they're doing. So that's one of the big issues. The other really big issue is the expert evidence, which did not stand up under cross-examination. So there is an absolute right under our Constitution, pre- and post-charter, for anyone to express a minority or dissenting opinion about anything, but particularly matters of public importance. So we will argue that there is no basis to censor or penalize Mark because all he was doing was expressing a minority or dissenting point of view on COVID science and COVID public policy.
Interestingly, the scheduled in-person hearing pivoted to a virtual-only hearing last week, which Alexander says is unusual.
This is the most controversial case, I'm sure, that the divisional court will address this year. So I find it unusual that at the last moment they want this to be done virtually. I was hoping for a live hearing. It's to our advantage to have a live hearing. And I want the public to see this live. I wanted the public to see it live. I mean, the chemistry in a hearing shifts constantly. And you will change what you're saying and what you're arguing. It'd be better to say you place an emphasis, a different emphasis on your arguments depending on the chemistry in the room. And that's a complex, judgment that you make. It involves, the way the judges look, their comments, the tone of their voice, the reaction of opposing counsel, your own feeling overall about what's going on in the courtroom, and how all of these factors are interacting with the people who are in the courtroom. And so I'm good at playing with all of that. I also would like to see college counsel put on the spot. I'd like to see their reaction when they are presented with arguments that are difficult for them to defend or incontrovertible. And I'll tell you another thing is that, say, in the case of the college, in a courtroom, usually you can have two people sitting, at the table before the court, so maybe a senior lawyer and a junior. What the college does is, they have two lawyers there, but then they have a whole team of lawyers in the room, and clerks and assistants, helping them in real time, with comments, cases, research, and so on. And so that gives them an unfair advantage. That's an advantage they would never have in a courtroom.
For those interested in attending, I will include the Zoom link for the hearing in the written copy of this report, so please be sure to check the links. Now, interestingly, around the same time the court transitioned to virtual hearings, Alexander and Trozzi's website, Justice for Medicine, was hacked, which severely disrupted their fundraising efforts for these legal battles.
Yes, very strange. We've had this server up for close to 2 years. And it's a site where we provide updates and information to people who follow us. So you can sign up for a newsletter and case updates. We also take donations on the site. And just out of the blue, the site was hacked and people couldn't donate. So that really hurt us because we had some fundraising events in the last week in different cities in Ontario. And so some people came forward after those events and wanted to donate on the site, and they couldn't.
All of these efforts are crucial to appeal the college's decision to permanently revoke Trozzi's medical license and impose $100,000 in charges onto him, which Alexander elaborates on here.
In effect, it is. Under the college's rules, they can charge $10,000 a day for their lawyers to attend a hearing. So we had several days of hearings in different proceedings with Mark. So that's how we got the $100,000 bill. What's unfair about that is that if we, for instance, had been successful at the tribunal, we would not be able to claim costs. So if the college wins, they get to put this huge legal bill on your side, which you must pay. But if you win, you get nothing. So this tilts the balance, obviously, in favor of the college. Doctors are afraid to go to a tribunal hearing in case they lose and they face these huge legal costs. And then if they win, they're out of pocket to their own lawyers. And so either way, they are going to get really jammed up financially. So it's a terrible system. It's designed to be unfair, and the legislature should do something about it. If we were to win this case, it would not only roll back the authority of the College of Physicians and all the health colleges in Ontario, it would roll back the authority of the administrative state generally in this province and across the country. I mean, we pitched this case from the very beginning 3 years ago at the highest possible level in terms of legal principles. So if we had to, we could take this all the way to the Supreme Court of Canada. So the stakes are very high, and this is true with freedom of expression as well. So we are suggesting that the understanding of free expression, which is current in Ontario and in some other provinces, is incorrect. And the predominant view is that the right can always be regulated to some degree or other under Section 1 of the Charter of Rights. And we're making the argument based on case law on free speech that goes back to 1939 that balancing is inappropriate when the state is trying simply to shut someone down because the individual is expressing a minority or dissenting opinion. So there is no state objective that can ever justify state action designed to shut down someone on that basis. So if we win that, we will change the way that courts in the country are looking at free expression currently. Although our position on this is grounded in Supreme Court precedent over 80 years. It's just that the constellation of cases that we have decided to rely upon have not been used in this way by other lawyers for some reason. I don't know why, but this will be a sui generis argument.
As mentioned, Trozy's case will be heard tomorrow, October the 8th, from 10 a.m. until approximately 1 p.m. Eastern. And while a decision is expected to come in the months ahead, the outcome will ultimately raise critical questions about our political landscape and the trustworthiness of the justice system itself. The implications of this case extend far beyond the courtroom, potentially shaping the future of governance and public confidence in legal institutions. And yet the general skepticism of the COVID-19 groupthink public health response as inflicting more harm than good hints that dissident doctors were right all along. For Rebel News, I'm Tamara Ugolini. The censorship and suppression of dissenting minority medical opinions was one of the worst aspects of the COVID handling. And if our reporting at Rebel News is any indication, it's only going to get worse. To stay up to date and support our work, please head over to stopthecensorship.ca and sign up there so that you never miss a report. That's stopthecensorship.ca.